Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today.
Hi there, welcome to Legal Listening. I'm Zach, and today we have a special bonus episode for you in collaboration with the Legal Writers Collective. Today, I'll be reading the Ontario Court of Appeal decision of Her Majesty the Queen and John Paul Stone. Before I begin reading this case, I do want to offer a content warning for our listeners. This case deals with sexual touching of children, as well as sexual interference, as well as trafficking of substance under the Controlled Drugs and Substances Act. This content is not for everyone, and I advise that our viewers take special caution when listening to cases like these because they can be very difficult to hear at times. As such, viewer discretion is advised. Court of Appeal for Ontario, between Her Majesty the Queen and John Paul Stone. Heard on July 3rd, 2020, by video conference. The decision in this case is provided by Justice of Appeal Durans. Overview. On a 19-count indictment, the applicant pled guilty to 4 offenses, including the offenses of invitation to sexual touching, contrary to Section 152, Count 7, and sexual interference, contrary to Section 151, Count 16, under the Criminal Code, Revised Statute of Canada, 1985, Chapter 46. The other 2 offenses were trafficking a substance included in Schedule 1, methamphetamine, contrary to Section 51 of the Controlled Drugs and Substances Act, Statute of Canada, 1996, Counts 18 and 19. The parties filed an agreed statement of facts in relation to the 4 counts on the understanding the court would hear evidence about disputed facts pursuant to Sections 723 and 724 of the Code. The Crown called 8 witnesses and the defense called 2 witnesses. Based on the agreed statement of facts and his findings on the evidence beyond a reasonable doubt, the sentence judge described the applicant's offenses as, quote, a toxic mixture of sustained trafficking and methamphetamine to numerous adults and children over prolonged periods of time, with clear evidence that the trafficking to children was used as a means of grooming and facilitating sexual abuse in relation to those children, end quote. The sentencing judge imposed a global sentence of 6 years in custody. He thought it appropriate to impose higher sentences on the trafficking counts than on the sexual counts because, quote, the more pervasive methamphetamine trafficking activity, essentially forming the manipulative platform or tool used by Mr. Stone to enable his perpetration of repetitive sexual misconduct in relation to his numerous young victims, end quote. He imposed a custodial sentences of 3 years on each of the trafficking convictions, 20 months on the invitation to sexual touching conviction, and 22 months on the sexual interference conviction. The trafficking sentences were made consecutive to each other because they stemmed from, quote, 2 non-overlapping periods of trafficking, end quote. The sexual counts were made consecutive to each other as, quote, they occurred at different times and involved different victims, end quote. Each sentence for sexual conviction was made concurrent to the trafficking conviction in the corresponding time frame. This resulted in a 6-year global sentence. The applicant seeks leave to appeal sentence and applies for release pending that appeal. The Crown did not oppose granting leave to appeal sentence. Leave to appeal sentence is granted. Counsel for the applicant submits that the sentencing judge did not take into appropriate consideration the prolonged sexual abuse that the applicant had suffered earlier in life, and that all sentences should be concurrent rather than consecutive. The submission counsel presses most strenuously is that the applicant should be granted release because of the COVID-19 pandemic. She has filed a lengthy affidavit from Dr. Aaron Orkin, an expert epidemiologist, who outlines the risk of the spread of COVID-19 in congregate facilities such as jails. Dr. Orkin sets out data showing that the prevalence of COVID-19 in Ontario correctional institutes is several magnitudes higher than the prevalence in the general population. He does not set out the equivalent data for federal institutions. He explains that jails are in the category of what he terms, quote, not fully voluntary congregate settings, end quote, also known as NFVCS. He accepts that NFVCS remain, quote, in operation because of their socially essential function, end quote. However, he states that from a public health perspective, it is preferable to, quote, depopulate and decongregate, end quote, these settings rather than resort to secondary mitigation strategies. He points out that, quote, every admission prevented and every resident discharged or released is an opportunity to flatten the curve and improve health for the individual involved, other inmates in the facility, the staff at the facility in question, and the public, end quote. Dr. Orkin also foresees a second wave of outbreaks in correctional facilities in the future should mitigation measures be relaxed without reducing populations. Dr. Orkin acknowledges his perspective is from a, quote, medical and population health perspective, end quote, and that, quote, a judicial official deciding whether or not to detain somebody will take various factors into account and will have to balance public health and individual safety against factors set outside of his area of expertise in determining what is in the community's best interest, end quote. Analysis. Section 679, sub 4 of the Code sets out 3 criteria of which the applicant must satisfy the court on a balance of probabilities to obtain release pending appeal. A. The appellant has sufficient merit that, in the circumstances, it would cause unnecessary hardship if he were detained in custody. B. He will surrender himself into custody in accordance with the terms of the order. And C. His detention is not necessary in the public interest. 1. Section 679 sub 4 sub A. The legal test of, quote, unnecessary hardship, end quote, under section 679 sub 4 sub A depends on the likelihood of the applicant would spend more time in custody than his sentence is ultimately determined to be, considering the merits of the appeal. See the Queen and Hassan. I see little merit in the appeal. The sentencing judge discussed at length, quote, the reality that the applicant himself is the victim of devastating, prolonged, and horrific sexual abuse, end quote. It was up to him to weigh that circumstance. As well, there is no error in principle in the sentencing judge's reasons for imposing consecutive sentences for the trafficking offenses and for the sexual offenses. The applicant supplied methamphetamine to 17 different identifiable individuals over 2 distinct time periods, 2 of whom were complainants in the criminal code offenses. The applicant concedes that the global sentence was within the range of sentences for those offenses. In my view, there is little prospect that the appeal will result in the appellant spending more time in custody than his sentence is ultimately determined to be. In my view, it is that the appeal, even if successful, would be determined before the term he must ultimately serve has expired. 2. Section 679 sub 4 sub B. The Crown pointed out in 2017 the applicant had been charged with failing to attend court and that the charge was withdrawn when he pled guilty to the other charges. However, she did not press the application of section 679 sub 4 sub B. I am satisfied that the applicant has met his onus on this ground. 3. Section 679 sub 4 sub C. It is in the public interest that the spread of COVID-19 in correctional institutions be minimized. The current COVID-19 pandemic is a factor that is to be considered in assessing the public interest criterion. See the Queen in Obiter and the Queen in Gesso. That said, the primary responsibility for the safety of inmates in federal correctional institutions lies with the federal government and Corrections Canada. The applicant points out that the Honourable Bill Blair, Minister of Public Safety and Emergency Preparedness, on March 31, 2020, recommended that the Superintendent of Prisons and the head of the Parole Board consider releasing inmates. The Superintendent and the Parole Board may have resort to special powers to grant early parole to inmates whose release will not pose an undue risk to the public. In contrast to the comprehensive perspective Corrections Canada may take, the focus of a court is necessarily solely on the individual case before it and the administration of law. The fact is that the appellant has been sentenced to 6 years in custody in a federal penitentiary. Being on release for a few months now will not change the fact he must serve his sentence and may be serving it during the second wave of COVID-19 that Dr. Orkin foresees, should it occur. In this case, the applicant is in custody at Bath Institution, where no inmate has tested positive to date. The applicant is diabetic and a former smoker and says he is especially vulnerable to the virus. He attributes his high sugar levels to being incarcerated. The Crown has introduced evidence that he has consistently been purchasing from the canteen a high number of products high in carbohydrates such as pop, cookies, Swiss rolls, and Fudgio cookies. The evidence does not satisfy me the applicant's high sugar levels are attributable to his incarceration. If, in the future, there is an outbreak of COVID-19 at Bath Institution, it will be up to the prison authorities to take appropriate measures to ensure the health and safety of those who are incarcerated or work in the institution, as well as that of the general public. In this individual case, the applicant has not satisfied me that his detention is not necessary in the public interest. In addition to the considerations noted above, the evidence shows that the applicant has previously breached recognizances, breaches that involve the use of drugs, access to a computer, and the internet, and child pornography. Troubling is the sentencing judge's finding the applicant has no insight into his sexual preference for prepubescent and pubescent individuals. His planned release is weak, proposing his spouse as surety and that he will be released to live with her. As noted, the applicant has committed offenses while on bail before, albeit not with his spouse as surety. The acts for which he has been sentenced are serious crimes against children. Disposition. Having considered all the applicant's submissions, including those relating to COVID-19, I am not satisfied the test for granting release pending appeal is met. The application for release pending the appeal is dismissed. I order the preparation of the transcripts, if necessary, and the appeal to be expedited. The parties may have to arrange an expedited date with the court's appeal scheduling unit.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course, guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.